As you said, I'm Gian-Franco Melendez. Went by Franco in high school most of the time. And I do practice a couple areas of law. One of those is real estate. And as an attorney who practices real estate, I do help, buyers and purchasers with negotiating contracts, figuring out the right kind of deed, go to closings with them. But a large proportion of clients that come to me when it comes to real estate matters, they come to me when things go wrong. And the crux of what I'm going to talk about today has to do with ways for you guys as real estate agents to avoid that. It's a pleasure meeting you today, but I do not want to see you guys in a courtroom. I'd rather avoid that. I'm going to start by telling you guys a little bit. When a client's going to come to me, they're just trying to look, buy properties, and I know agents, but maybe they want to find one on their own. A couple of things I like to tell them to look out for, to ask when they are looking for the right agent for them. And I'm not really trying to tell you guys how to answer those questions, but I want you to keep them in your mind because people like me are telling people these types of things. So have an answer for them. Tell them to shop around, especially if they're selling. At least 4 or 5. Interview them, ask them how often they sell in the particular neighborhood they're looking to buy or sell, how long they've been an agent. Make sure they're a full-time agent. Do they specialize or sell a lot of homes or properties in the neighborhood that you want to buy or sell? Make sure they deal with your type of property on a regular basis, whether it's residential, commercial, agricultural, what have you. Make sure they're asking you the right questions so exactly what you want out of that agent's services. A late 20s couple with a baby probably going to want something different than a guy who just retired who's looking to buy a beach property. You got to cater to your audience. Tell them to get references. So if you have a particularly good sale, make sure to keep that relationship going. That will come in handy in the future. And we all know about Zillow. And now everybody goes on Zillow or one of those other sites, and all of a sudden they're a real estate expert. Just be aware of that and be ready to correct or inform them on their misconceptions or what they think they know, because there's a lot of smart alecks out there. But that's not why I came to talk to you today. That's just something that I felt might benefit you. I don't know. What I came to talk to you today is how agents can get in trouble and a couple of strategies for you guys to avoid that. Now, a huge one is failure to disclose material property defect that you know or should know about. The word material pops up a lot in legal theory and in statutes. And so material defect is something substantial. It's a property defect that you know will substantially affect the market value of the property. So say we have a property, and if it's in good condition and everything's fine, it'd be worth $100,000. Now it's got a defect that because of that, it's now worth $70,000. That's material defects. That is something that you need to try to find out if possible and disclose right off the bat. And that's an extreme example of 30% decrease in price, but even if a couple grand is material to some people, if it's $1 million listing and there's a $2,000 defect, maybe that's not material, but you should still disclose regardless. It's as agents, it's in the statute that you need to disclose anything that not only that you know of, but that you should know of. You have to do your due diligence to make sure that you're covering your bases and making sure that whatever that listing says is completely accurate. you get in a lot of trouble if it's not. Florida statute also says that a seller has to disclose any material property defect that they know of and that they know will materially affect the market value of the property. Especially if you're representing the seller, ask the right questions. Do your CYA work. CYA is cover your butt. I know that acronym doesn't quite make sense, but you know what I mean. Ask the right questions. Kind of grill them. Be like, hey, is there any issues with this house that you know about, or that any issues that you think might come about? For 3 reasons. One, so you get ahead of it in terms of trying to promote the property and the listing. 2, you don't want your deal to fall apart a week before closing because you've had this contract for purchase signed and done, and then a week before closing, you discover a defect. These things can happen, and it's just, something that can happen without anybody being at fault. But doing your best to figure this out before it becomes an issue is in your best interest, and in the best interest of the client. But 3, most importantly, you will hopefully prevent yourself from being exposed to liability in the legal sense. So when you're talking to the seller, ask them, is there any defect that I should know about? This is big. Explain to them why you're asking this. This is really important. If there's a defect, tell me now so that I can get ahead of it. So that, either A, we can fix it if it's something that can be fixed quickly and easily, without too much expense, or B, so we can get ahead of it and figure out ways to market the property in other ways, highlight its other attributes to make sure that, at least to entice a buyer to purchase the property in spite of the defects. And explain to them that as a real estate agent, you have a duty to inform, to disclose these defects. And then you can also tell them, look, under Florida law, sellers have to disclose defects, material defects in a property that they know of. And if you're asking me to not disclose this to any potential buyer, maybe I'm not the right real estate agent for it. Now, that last bit teeters on something that I'm going to get into a little bit later, which is giving legal advice, which please don't do that. But that is such a big no-no that I'm going to spend a little bit more time on it in a second. But as long as you're just telling them, Florida statute says that a seller has to disclose material defects they know about. That's not really giving legal advice, you're just telling them what the law is. That's okay. Going beyond that, you're playing with fire with it. But I'll get into that, like I said, later. Again, CYA. A lot of interactions you're going to have, just by the nature of what you do, is over the phone and in-person conversations. But get things in writing, whether it's text, email, letter, if you can. After a conversation on the phone or in person, stop for a second, take a detailed notes of that interaction. Who, what day, what time, who you were talking to, what they said, and if you have an interaction or a conversation with someone and it seems fishy or troublesome or a little sketchy to you, go with your gut. If you have their email, send a follow-up email confirming what was said. As an attorney, I like to leave a paper trail of everything that happens with the case. Because if something happens down the road, I can follow that paper trail and be like, look, no, I did everything that I needed to do. My client did everything that we needed to do. We're in the clear. We're good. You just gotta CYA at all times. It's a good life philosophy, but with careers such as like attorneys, real estate agents, engineers, doctors, people who have duties to other individuals, CYA work is incredibly important. Because if a material defect is discovered down the road, it doesn't matter whether the seller didn't tell you about it, whether they didn't know. If that buyer sues, that buyer is going to name you as the agent along with the seller in that lawsuit. And, you know, as an attorney, I make a living off of, in part, lawsuits. It's the nature of my business. But being in one is not fun or cheap. I know because I represent people in them, and it's not fun. And I'm sure at some point or another, most people, you know, they deal with them and they know it's not somewhere you want to be. So you want CYA to avoid that at all costs. You want to be able to honestly say, look, I did my due diligence to discover any potential or existing defects. I asked the seller multiple times. I was very clear with them. I thoroughly and personally examined the property myself. I recommended the inspections. I got the inspections done. I did everything I could. And two, you want to be able to physically show that if possible, right? Another way that real estate agents can get into trouble is misleading clients or just other parties. As I've been saying, there's a duty to disclose material defects. So there's a defect in the property. I told the buyer, I'm good. And then, you know that defect is like a $30,000 defect, and you're like, it's a $2,000 defect, so no big deal. Yeah, that's not okay. You don't want to do that. That is how you see me for non-fun reasons. Another way that real estate agent can get into trouble is negligence, which is closely related to breach of duty. Negligence is a phrase that gets tossed around a lot nowadays. You hear it on shows like Suits and Law and Order and stuff like that. A lot of people don't know exactly what it means in a legal sense. So negligence has 4 elements: duty, breach, causation, and damages. As a real estate agent, you have a duty, a legal duty, to act in the best interest of your client. An agent is a very specific word, and an agency relationship is a specific legal term. And an agent is supposed to act in the best interest within the law of whoever they're an agent for. In this case, it's the client or whoever has hired you for your services. So the first step, if you're working a listing, that first element of duty is there. And you not only have a duty to the client to act in their best interest, you have a duty to any other interested parties or buyers or sellers, because you have, like I said, a duty to disclose, and there's several other types of duties that an agent is supposed to abide by. Second element is breach. So to breach a duty, you have to act in a way that is different or inappropriate in light of what a reasonable person in the same position doing the same thing is supposed to do. So failing to disclose a material property defect, it's a breach. Misleading a client or others, it's a breach. Taking on another listing when you know you're swamped and you don't even have time for the ones you have, that's a breach. Taking on a project that's bigger than what you're ready for, something that's outside of your realm of understanding, and not seeking help, that could be a breach. And then the third element is causation. So there has to be a direct correlation between that breach of duty and damages to another person, and 4 damages. In a real estate transaction, it's mostly economic damages, so money missed out on a deal, things like that. But potentially, depending on how egregious the behavior is, potential punitive damages. So ways to make sure that you're doing things correctly and not breaching your duty as a real estate agent. Making sure that you have the full, proper legal description in the contract, not just the one from the property appraiser site. Property appraiser site is wrong all the time. Nico's told me that you guys have a software that helps you with that a little bit, but don't just rely on it. Go back and look at the prior deeds. They don't change a lot. They do change sometimes. If the deed is from 1910, maybe it's not super accurate, but it could be. But just do your homework and do your due diligence and make sure that the legal description is correct. Make sure you know the difference between types of deeds. This is huge. There's a number of different deeds, but the three main ones in Florida are warranty deeds, fee simple deeds, and quitclaim deeds. Now, a warranty deed is really great for the buyer, not as great for the seller. Basically, with the warranty deed, the seller is, so I sell you a property, the warranty deed. I'm warranting or promising you that from the beginning of the life of that property to the time that I bought it, from the time that I bought it to the day that I sell it to you, no liens, judgments, other assessments, other title issues have attached to that property. It's free and clear. Obviously, it's great for the seller because they get insurance for the buyer, it's because they get an assurance from the seller that the property is free of title issues. Someone gives you a warranty deed, that doesn't mean you don't have to get title insurance. That's crazy, but that's just what that means. The fee simple deed, not as good for the buyer, a little bit better for the seller. With the fee simple deed, the seller is, saying, I don't warrant or promise anything about this property from before the day I bought it. But from the day that I bought it to the day that I sell it to you, it is free and clear from any judgments, liens, or other title issues. And then a quitclaim deed is great for the seller, not so great for the buyer. Basically, just selling it as is. I don't promise or warrant a thing. And if there's title issues on it, or judgments or liens, that's the way you're buying it. So, especially if you're working with a title company and you give them a quitclaim deed, they're going to look at you a little funny a lot of the times. Like, what's the point of this title insurance if the buyer is buying it as is? If a real estate transaction that you're working on necessitates or you have an inkling that it should require some title work done to it, don't use a quitclaim deed. Now, if I own a property and I want to deed it to myself and my son so that my son has an interest in the property, quitclaim deed is probably fine. But for most transactions, quitclaim deed, be careful with those, especially if you're representing a buyer, because any liability in the history of that title of that property, they could pretend, they might be on the hook for, even though they didn't even own the property when that lien or judgment attached. Know when to ask the right questions, and certain questions are always the right questions, such as, are there any defects? If the buyers are a couple, are they married? Are they about to get married? Is this property being sold due to a divorce? It's huge. Is this property going to be used as a residence because there are possible homestead and tax implications? What's the intended use and future use of that property? Again, if anything borders on legal advice, send them to an attorney. Make it very clear to them that you're a real estate agent, and of course, in your time as a real estate agent, you learn a lot about the laws, but you can't get legal advice. Another way that real estate agents can get in trouble is breach of contract. This usually has to do with not doing things by a time frame contained in the contract or specific provisions. That's just making, to not get in trouble for breach of contract, just do what the contract says. Another way you can get in trouble is not recommending inspections. Please don't do that. Always, always, always recommend an inspector. If you don't have a good relationship with an inspector, ask your colleagues. Try to have 2 or 3 that you can rely on. We live in Florida. Try to build a relationship with an inspector that speaks Spanish. On the one hand, it might make your client feel a little more comfortable. If English isn't their first language, and the biggest minority here is Hispanics. But 2, you might avoid any loss in translation issues that could down the road potentially lead to a lawsuit, or you getting in trouble with your license. Another no-no: don't forget to recommend title. That's huge. If the title is all messed up, and so my buyer goes to buy this property from this individual, turns out the individual doesn't actually own the property. They just spent $300,000 on a piece of paper. That's not good. We don't want that. And I have a title company in my office that I use for every deal. And it has made having a title agency that you trust and that you can work with comfortably makes all the difference in the world. Now, biggest thing, do not give legal advice. I'm going to say it again. Do not give legal advice. It's not only a bad idea because you might be wrong, it's illegal, which is worse, obviously. Yes, you guys do your homework. You took the classes, you took the exam. You're working with Nico, so you're obviously competent, and maybe you're new at this, but you're trying to be competent. You're trying to learn everything, do your homework, and be a good agent. But you cannot give legal advice. You cannot practice law. Some issues that arise with real estate's practicing law is vesting issues. How do you name people on the deed? There's different kinds of joint, with single ownership. If I'm buying a property by myself, it's not a big deal. Where it comes into play is with joint ownership. And in Florida, there's 3 main kinds. There's tenancy in common. Tenancy in common, say us 3 own property together. I can sell my interest in the property without your permission to whoever I want. If I die, it goes to my heirs, and the ownership interest will have to be the same. She could own 40%, you could own 40%, and I own 20%. I can only sell at 20% interest, and my heirs only get 20% interest. That's how it works. And there's joint tenancy, which is most often used as joint tenants with right of survivorship. Now, you technically can sell your share to a third party, but their share becomes a tenancy in common, and the other parties retain right of survivorship. So if all parties have right of survivorship, they all own the property equally, they all own the whole of the property, and if us 3 have property with joint tenancy with right of survivorship, and I pass away, then you guys just absorb my share equally. If one of you passes away, then the other person gets all of it. It's not inherited. And it's still, both of those still have tenancy in common and joint tenancy with right of survivorship, still have to go through probate. But they're very different. And if I sell a property and the deed says, I sell to John and Steve, it's automatically going to be a tenancy in common unless it specifically says as joint tenants with right of survivorship. If it's unclear about what type of ownership interest those parties have, it's going to be tenancy in common, and those are two very different things. And that's something that only a real estate attorney should really be discussing with somebody. Now, where a lot of issues happen is when there's a couple and they're either about to get married or they are married, because as two spouses can retain ownership of the property and buy ownership of the property as tenants by the entireties. And you'll know when a deed, and this is important for other reasons, but you'll know when a deed is set up this way when it says like John and Sue as husband and wife. That's gonna be a tenancy by the entirety of those people, and that's very important because one, this type of ownership provides homestead protection in probate and in general. It's similar to joint tenancy with right of survivorship, but, and this is why I said it's important to notice this, me, husband, can't convey the property that I own with my wife as a tenancy by the entirety without her permission. Can't do it. Another important part of this type of joint ownership is if one spouse dies, the surviving spouse owns the property entirely without the need of creating a deed. You don't have to go through probate, and the homestead protections are retained. If the spouse is divorced, it reverts to tenancy in common. Basically, each spouse owns 50% of the property. But where an attorney comes into play with this is, so ownership by tenancy by entirety creates a lot of issues in real estate. They're homestead issues. Florida is only one of two states with homestead protection. So if you're coming from out of state, you've been doing real estate in Illinois or whatever, and now all of a sudden you're doing, I don't know if Illinois is the other state, I can't remember the other state right now, but a state that doesn't have homestead protections, that's stuff that you need to at least become acclimated with, because there's a lot to homestead. I could do a whole nother 30 minutes just on homestead protection and tax exemptions that have to do with homestead and how those, the rights of the spouse and probate and real estate matters, but that's not what I'm here to talk about right now. But again, that's something that your client should be talking to a real estate attorney about if that's an issue. Again, with spouses, liability. So I've owned this property, I get married, I want to deed it to myself and my wife as husband and wife as in a tenancy by the entirety. My wife has a bunch of debts and judgments against her. Those debts and judgments can attach to that property. Now, if it's our homestead property, it's protected from creditors while we live there. But when it comes time to probate, or maybe we just want to sell the place, those judgments and liens are going to rear their ugly head, and it's not going to be fun. Because they're going to, when you make the sale, they're going to take their chunk before you see a penny, depending on the priority of the liens. If a couple is about to get married, if they buy the property before they get married, they won't have the tenancy by the entirety protections. They're going to buy as tenants in common, unless you have the deed specifically say, John and Sue as joint tenants with right of survivorship. They're still not going to have some of the other protections that tenancy by the entirety would have, but they're protected a little bit. Again, these are all very complex legal issues that you should not be, you can tell them, what some of these terms mean, but don't be advising them one way or the other on these matters, because you can get in a lot of trouble. Not just a lawsuit by them if you're wrong, but a lawsuit from the Florida bar. And the Florida bar is entirely made of lawyers. So You don't want to get in trouble though. Divorce. Title companies and attorneys see real estate issues related to divorce, division of assets and divorce all the time. Issues with debt and property the debt is secured on. So I get divorced. I own the property with my wife. I'm like, you have property. I'll take the debts on the property. Those debts are secured with that piece of property. I default on those debts. I don't own that property anymore. Doesn't matter. Those debts are secured on that property. What do you think what do you think the lender's gonna do? And take that property. That's not good. So you might be working with a client, especially in this, aspect, and they say, my divorce attorney or my friend who's an attorney said I should do this. This is a red flag. Huge red flag. If you hear this, your ears should perk up. If it sounds wrong to you, or maybe you're just not sure, you should probably say, I'm not an attorney, but that doesn't sound right to me, or I'm not sure if that's true. You should speak to an attorney who practices in real estate. Your divorce attorney or your friend who's an attorney might not. And most divorce attorneys don't practice real estate. So title agents and other attorneys often see these real estate issues because family law attorneys are trying to practice real estate and they don't get things just right. And it can have just the smallest thing can have a huge impact. Probate, if somebody passes away, liens and debts left by the decedent, there's homestead protections for the spouse. These aren't things that real estate agents should be really advising anyone on, so they're not attorneys. Another thing about not practicing law, if you know a client has a lot of properties, they want to buy, they're an investor and they want to buy like 10 properties, and they mention that they want to, buy them in such a way to protect them from predators and protect those assets for their family and their future. You could tell them about individual land trusts, revocable living trusts, irrevocable trusts, LLCs. You can tell them that these things exist and that they can help them to protect their assets, but you can't advise them on it. Tell them that an attorney can help them decide which type of asset protection structure is best for them. And finally, if you don't have professional liability insurance, get professional liability insurance. You can do everything that you possibly can to CYA and to do everything the right way. But sometimes you might not be at fault. The buyer or the seller breaches a provision in the contract. They do something wrong, they fail to disclose a material defect. It doesn't matter that you did everything right, that you did your best. You did your due diligence to make sure that everything was on the level. You're probably going to get named. There's a good chance that you're going to get named in that lawsuit along with the other party. So CYA. Put yourself, no one wants to be involved in a lawsuit. Put yourself in the best position possible in case the worst happens. As an attorney, my business is, a lot of the time, is lawsuits and litigation. Sometimes you have to go to court to get what's owed to you or your client, or to right a harm that was done to you. And that's great when if you do that and you win and you get what you deserve, or an injustice is reversed or made better. You know what's better than that? Doing your CYA work, having everything documented, and when that other person tries to make things difficult for you, or that bad thing happens, you go to the other party and say, "What? I have all this. Do you want to fix this and make things right, or do you want to go to court?" They're going to say, "Okay, this person has me dead to rights. They they did everything right and they can show it. I'm going to fix this, or make this right. And you don't have to go to court, and you have to deal with the not just emotional grief, but financial grief. They're expensive and they're stressful. So just making sure that you protect yourself as much as possible will not only, it's not only good for yourself in protecting your license and your livelihood, but it'll make you a better agent. Protecting yourself and doing your due diligence will protect your client and the people that you're interacting with and working with. And that's, it's kind of why you do what you do, right? You're selling that home to that young couple with a new kid that's going to be their family home for the next 20 years. You're selling that beach condo or that mountain house to that older couple who's been busting their butt for their entire lives to retire and just enjoy the rest of their lives. It's important stuff. So just make sure you do your due diligence, your CYA, and everything else should sort itself out.